This just in, the Supreme Court has ruled in favor of a high school football coach in Washington state who says he lost his job for kneeling and praying at games. The decision could have a ripple effect for other cases involving separation of church and state. For a breakdown and analysis of this case, I want to bring in CBS News politics reporter Melissa Quinn and CBS News legal contributor Jessica Levinson. Melissa, I'm going to start with you. If you could tell us about this case. It took a pretty long path through the lower courts before finally making it to the Supreme Court.
Yeah, you're absolutely right. So this conduct from Coach Joseph Kennedy, who was a former assistant football coach in a small town in Washington state, began all the way back in 2008, I believe it was. He engaged in these brief, quiet, he says, prayers on the 50-yard line after his high school football games, and was soon joined by the teammates or the students on the opposing team. And his prayers eventually grew into, he says, motivational speeches. This court wound its way through the lower courts, actually ended up before the Supreme Court once time before, where it was kicked back to the lower courts, and that brings us to where we are today, with the justices ruling 6-3 along ideological lines in favor of Coach Kennedy, saying that these brief, quiet religious expressions were protected under the First Amendment.
All right, so Jessica, we just showed a picture there of Coach Kennedy kneeling in front of the Supreme Court of the United States, and I applaud him for being able to do that. That is what we have in this country. He's able to do that. It's a public space, and the Constitution guarantees him that right. But explain to us the arguments, the legal arguments that this case, that the justice has made in this case, and more importantly, I guess, what implications this could have for other cases involving the separation of church and state, because it's a discussion that we had in the last hour, and I asked you about if I am a student, if I'm a football player on that team, and I am either not religious or I subscribe to another religion, what that could mean for me in this now ruling.
And if I can, I just want to say, I'm looking at some pictures of the moment. There were at least 3 times where this happened. I'm counting 35, about 50 students all around him. So we're talking about a private moment, according to the Supreme Court. But
if I don't participate in that, what does that mean for my position on the team?
Exactly.
Can I still be a starter?
So I think that the conversation we're having, frankly, is exactly the conversation that the majority has with the dissent here. And it's one that is really important to pull out and highlight. So what we have here is the majority saying, well, look, just because you work at a public school doesn't mean you give up all of your rights as a private individual under the Constitution. And so when it comes to Mr. Kennedy, he can, even when he's in his uniform, even when he is at a high school football game, he can have a private moment where he goes to the side, where he engages in a prayer. And that's how this started. And that's what he claims he just wants to be able to go back to. He can have that private moment, that's his speech. It's not the government speech. And that if we tell him he can't engage in that speech, we're actually discriminating against him. What we see here from the dissent is, I think, the flip side of that, which is what we've been talking about. There were a lot of students surrounding him. How would those students feel if they either are not religious or of a different faith? Would they fear that they would get different treatment, for instance? They maybe wouldn't start in the football games. Maybe they would face some sort of repercussions. Justice Sonia Sotomayor in this dissent really talks about the idea that this would, in fact, put pressure on other students. And she says, let's not divorce this from the circumstances. You know, again, he's wearing his uniform. He's surrounded by students. He's still, in general terms, responsible for them. He might not be calling a play, but he's still, in general terms, responsible for them. And so I really think what you see between the majority and the dissent is the majority saying private speech and we can't discriminate against him, and the dissent saying this looks more like public speech to me. And I'm more worried about the government endorsing religion and this particular religion and all the bad things that go along with that.
That's really an interesting point there, Jessica, because it seems like the court is looking at these same images and interpreting them differently, whether it constitutes a public endorsement or it's a private moment. Melissa, the ruling obviously fell along ideological lines. That doesn't seem particularly surprising. Was there anything in here that surprised you?
No, and I think what Jessica said is exactly right. You know, Justice Gorsuch spent a lot of the time in the majority opinion really emphasizing that, in their view, Coach Kennedy was engaging in brief, private speech. And what you see throughout Justice Sotomayor's dissent is sprinkled throughout there are these images of Coach Kennedy on the field after the game, surrounded by all of these people, just as you noted earlier. And she really criticizes the majority and said, you know, we can't ignore the fact that these students could potentially feel pressured to participate in these post-game prayers with the coach. And she criticizes the majority for basically putting the religious rights of Coach Kennedy and public school employees over the needs of these students, and says that the majority opinion is giving, quote, short shrift to the Establishment Clause. So you really do see that tension between this conservative majority and the three liberal justices who were in dissent.
So Jessica, I asked you about this in the last hour, about whether or not this was rolling back what people call the Lemon test, which comes from a case, Lemon versus Kurtzman. Can you just explain to our viewers what that is and why, in your opinion, this is not rolling back this precedent?
So, well, and I'm sorry, I should clarify. What the court is saying here is we're not touching Lemon because, again, they're saying we're looking at the same images. And this is not about official endorsement of religion, because they've concluded that this is private speech. And I'm sorry if I wasn't clear on this before. Justice Sonia Sotomayor says, and I'm going to quote here, the court now goes much further, overruling Lemon entirely and in all contexts. It is wrong to do so. And what Lemon is really about is whether or not we have a violation of the Establishment Clause, whether or not, and let's focus on the Establishment Clause, we have a situation where the government is either endorsing religion over no religion, or the flip side of that, no religion over religion, or one religion over another. And this is part of, and I think it's such a good question, this is part of what Justice Sonia Sotomayor is saying in the dissent, which is you're ignoring the Establishment Clause. You're ignoring our jurisprudence, our case law under the Establishment Clause, and you're just basically, to the extent you're paying attention to it, you're erasing it. And we talked about, you know, in the last hour that this is part of the court's, I think, steady march of saying, I'm looking at these two parts of the First Amendment. There's one part that says free exercise clause. You should be able to engage in religious activities without the government telling you don't do that. And then Establishment Clause, you should be free of a government trying to establish religion or favoring one religion over another. And what we see is the liberal justices saying, I'm really worried that you're ignoring the Establishment Clause. And with Justice Sonia Sotomayor, to get back to your question, Vlad, I'm worried that you're overruling our past precedent when it comes to trying to protect people from government religion. And then we have the majority saying, we're not even touching that. This is a free exercise case. This is a case about private speech. This is much narrower than you think it is. And so we're not broadening out to that. The conservatives have the majority. This will be a continuation of the type of opinions that we will see for years to come.
Jessica, I'm wondering, because you were saying that that what Coach Kennedy wanted was to be able to pray after a game. If it continues that it is involving lots of students, if parents feel like this is ostracizing my child, might any of this be reconsidered, or this is now fine for him to do fully as we saw, or there are some parameters?
I'm going to try and answer that really good question the best way I can, which is to say that there's really an argument, as far as I can see quickly reading the opinion, between the majority and what they characterize as happening and what they characterize as as Mr. Kennedy's claim here to be, which is that he just wants to go back to that private prayer. And frankly, what I read so far of the opinion is, and if students want to join him, he's not going to tell them no. We have Justice Sonia Sotomayor in the dissent saying that the court is misreading the facts of the case. And I think this is trying to get to your excellent question, which is the dissent is saying this wasn't just, he didn't just go to the side by himself. There were a number of students who joined him, and this became really a much bigger activity. Now, in terms of whether or not parents could complain and we could basically see a Kennedy 3.0, as Melissa said, this case has already come up once before. So that's why I'm saying 3.0, not 2.0. I think that this court has basically spoken on what they see as happening in this situation. Could we have another case, the next case, where it doesn't start in basically as private a setting, and it always starts with a number of students around that public school official? I think that's more likely to be the case, where we see the parameters of how private really is this activity.
Yeah.
It is fascinating to me, Melissa and Jessica, when I read the opinions in this briefing. And so here's Associate Justice Gorsuch for the majority. He writes, quote, "Respect for religious expression is indispensable to life in a free and diverse republic. Whether those expressions take place in a sanctuary or on a field, and whether they are manifest through the spoken word or a bowed head." Meanwhile, Justice Sotomayor writes this: "Today's decision is particularly misguided because it elevates the religious rights of a school official who voluntarily accepted public employment and the limits that public employment entails over those of his students who are required to attend school and who this court has long recognized are particularly vulnerable and deserving of protection." So, therein is the rub, right? I mean, I think most Americans would sit there and say, well, I mean, they're kind of both right, but in this case, the majority, because they have that majority, are the ones who are able to rule in favor of Coach Kennedy, Jessica.
I talk to my students about this a lot, where they say some version of, I'm looking at the dissent, and that's how I see the case. I think that's the better argument here. And first of all, I'm proud in those moments because they've, thought through the decision and they know enough to say, I agree or I disagree. But they basically come to, so that seems like it's the better argument here. What am I missing? And the answer, and I don't want to be glib, is more votes. You're missing being able to count to 5. And so we just see a different worldview, and some would say kind of a different conservative legal goal than we see in terms of the dissent, and maybe a more liberal legal goal here. And it is hard to escape the idea that this is not the last word, and it won't be. Again, this is not, the majority has said, this is not a school prayer case. But Sonia Sotomayor says, let's look at what's happening on the ground. He didn't have to agree to be a high school football coach. He works at a public school. The students have to be there. Now, they don't have to join the football team, but we don't want to be in a situation where we're telling people, if you join the football team, it entails, religious expression. Again, the majority is saying it absolutely does not. And so we're going to see this fight come up again. There's a case, and it deals with a separate but related question. It's going to be one of the big cases next term. I hope we all get to talk about it, where it's a Colorado website designer. And she says, my religious beliefs prevent me from adhering to the state's anti-discrimination law and serving LGBTQ couples. I'm not doing that. The court took that case. I suspect we know where the court's going.
That's going to be another big one.
It really is. And before we wrap this up, I know, Melissa, we're not expecting any more decisions today. This is it, right?
This is it for today, but we are not done with the Supreme Court's term yet. I believe after today, we still have 4 more opinions to come, including a big case involving the EPA and, of course, the Remain in Mexico policy. So while we may be all set for today, the justices will have more coming probably later this week.
Yeah, we heard that it's Wednesday.
Yeah.
We just saw on SCOTUS blog.